Hello, everybody. Thank you so much for joining us today. My name is Juan Carlos Brando, and today we're having this show with one of the attorneys in the law firm of Margaret W. Wong and Associates, which is one of the most important law firms in the United States of America. And today, for me, it's a pleasure to have the attorney Francis Fung Sang, who is one of the attorneys experts in several areas of the law, especially in work-based visas plus many other kind of visas. But today we have the honor to talk to the attorney Francis Fonsang. Hello, attorney Francis. How are you doing today?
I'm good. Thanks. How are you?
I'm doing good. Thank you very much, attorney Francis. Well, right now we have a lot of comments from people talking about the chances of coming to the United States on a special visa if they are engineers or nurses or doctors. Especially, there is supposed to be one new law in Florida that will allow people that have prior careers in their countries to be certified and start working as doctors or nurses certified in the state of Florida, and probably to get a visa based on that status. Have you heard anything about that?
Well, the important thing is that immigration is federal law. So to qualify for a visa, you have to qualify under the federal immigration law. States have no control over visas. So even if a state passes a law saying that foreign people can qualify for certain jobs, it does not necessarily help them come to the United States because they still have to apply through the Federal Immigration Service to get a visa approved and through the US Embassy to get the visa stamped into the passport. So we'll keep an eye on what's going on in Florida, but for now, I wouldn't get your hopes up that it will change anything with qualifying for a visa.
Okay, so in this case, we had a question a couple hours ago that a person is a designer. He designs kitchens or cabinets, and he's living in Colombia, but he wants to move to the United States with a professional visa or a work-based visa. Is that something that is doable for a Colombian person?
Well, unfortunately, the United States doesn't have a skilled worker program. That means you have to meet the requirements of a specific type of work visa in order to qualify. And usually you need an employer to sponsor you. It's not self-sponsored. Now, it's possible that if you're from Colombia and you want to invest into a US business or you want to start your own business, then you could apply for an E2, that's an investor visa, to start your own designing business. But otherwise, if you want to work for somebody else, you need a job offer to sponsor you. Now, there isn't a specific type of work visa that would meet this requirement because you don't need a bachelor's degree to design a kitchen. And it is not a seasonal type of job where you qualify based on working for a certain period of time during the year. And unless you've gotten awards or gotten recognition in the newspaper, it's going to be difficult to qualify as an extraordinary ability O1 visa person. So probably you're going to need a business in the United States willing to sponsor you for the green card through a process called labor certification, which could take 2.5 years or longer. Or you self-sponsor for a temporary work visa, the E2, to start your own business.
Thank you very much, Attorney Francis. And yeah, don't forget that you can call the phone number 216-279-3984, 216-279-3984, and you will be able to talk to one of the attorneys in the law firm of Margaret W. Wong and Associates. This next question says, Hi, I received a notice of intent to denial on my TPS application. I am from Venezuela, but got arrested due to family violence. Although the person removed the charges, the case is still in court, and the prosecutor says that it's going to take 6 more months plus the probation time. What can I do to try to get something from the court or to rescue my TPS application so they don't deny it?
Okay, so the law is that if you are convicted of a felony or more than one misdemeanor, then you are not eligible for TPS. Okay, one misdemeanor conviction is okay, more than one is not okay. So right now you've been arrested, your case is still in court, is not a conviction. But that case popped up on your background check, and so now the Immigration Service wants proof that you were not convicted of more than one misdemeanor. Now, I don't know what other criminal records you have, or if this is the only one, but the immigration is going to ask for certified copies of the charging document, which is the indictment or the ticket, and also a certified copy of the final disposition. What is the final result of the case? Are you guilty or are you not guilty? Now, because this case is going to take longer than 6 months, you probably won't have an answer by the deadline of the notice of intent to deny, which is usually only 30 days to respond. But you have to respond. Otherwise, they'll deny the case automatically. So I would get a certified copy of the charging document and something from the court showing that you have a future hearing date, and you explain to immigration the case is still ongoing. Now, maybe immigration says, will deny the case, saying you didn't provide the final disposition. If that's the situation, then after the case, the criminal case is done, you would file a new TPS application and explain what happened before. But they might keep the case open, the TPS case open, to wait for your criminal case to be completed.
Thank you very much, Attorney Francis. And yeah, this is an interesting case. We have another case or another question that we've just received. And this person says, I have ESTA. I want to move to the United States. I am a psychologist. What are my chances?
Well, first of all, ESTA, which is part of the visa waiver program, that's only for visiting as a tourist or as a business visitor. It's not to come here to work. It's not a work visa. So to come to the United States, to move here as a permanent resident, to get the green card, you would have to qualify somehow for the green card. That means either through family, through employment, or through self-sponsorship. Okay? Family. Do you have a spouse who's a U.S. citizen or green card holder? Parents, children. Employment. Is there an employer willing to sponsor you for the green card by offering you a job? Or are you so well known as a psychologist, whether because you've published papers in journals, you've been mentioned in the newspaper, you've written books, you've won awards, that you could be a person of extraordinary ability where you could self-sponsor for the green card? Or have you done so much that you could qualify based on the National Interest Waiver, or NIW, that your presence in the United States will help the United States, the general public, based on the work that you've done, okay? Or the last one, self-sponsorship. Usually that means investing. That means EB-5 or like a temporary visa, an investor visa, if you want to start your own business or invest into an existing U.S. business.
Thank you very much, Attorney Francis. Don't forget, the phone number is 216-279-3984, 216-279-3984. We have an interesting question right here, and this person says, I was deported. Well, I have a child with a disability. He has autism, or she has autism. The girl was she's been medicated and she has to go to 3 therapies every week. Could I have an opportunity to get my documents if I was deported with a felony, and would there be a chance?
Did it say whether the child is a U.S. citizen or not?
The child is a U.S. citizen, but the person is was deported.
And was the person physically in the United States now, or is in the home country?
It doesn't say.
Doesn't say. Okay, well, the problem is going to be if you have a felony, that means that you might be what's called inadmissible to the United States. Some cases, there's no waiver. For example, if it's a controlled substance, a drug conviction, there's no waiver unless it's marijuana possession. So you can't come back. Other types of felonies, it's possible to get a waiver, but you would have to apply based on hardship to a qualifying relative. Now, that could be a parent, spouse, or child. Okay. And so the question then is, how would you qualify to come back into the United States as a permanent resident? You would need some sort of sponsorship. So either you're married to a U.S. citizen and that U.S. citizen petitions for you, or you have another relative like a parent or a U.S. citizen child over the age of 21 petitioning for you. So the waiver for your criminal record is separate from actually qualifying for the green card. So you still need a way to qualify for the green card, and then you would need a waiver possibly for that criminal record. And the deportation. So you also need a separate waiver for the deportation, in addition to illegal time in the United States, and in addition to that criminal record.
Okay, thank you very much, Attorney Francis. And yeah, we don't have that any other comment from this person. But let's go ahead with the next question. This question says, "Hi, last weekend I was victim of a violent crime. Some black guys beat me up just because I am Asian. I guess, is there something I can do?"
Well, I mean, so the first question to ask is, did you report this to the police? And are the police starting an investigation? Okay. Anytime there's a victim involved in a crime, we think about the U visa. And that is for victims of certain crimes, which you will get a temporary visa, and that could lead to the green card if the U visa is approved. Now, it's not all crimes have to be a qualifying crime. For example, felonious assault. So if this was a violent crime and qualifies as felonious assault, then you might be qualified for the U visa, but the police department has to be willing to sign the U visa paperwork. That's the 918 Supplement B form. Okay. So you would talk to the police department. I would recommend victim services. They're usually more friendly, to see if they're willing to sign this form. And number two, you're willing to assist the police in their investigation to solve this crime. And if you can meet each of those requirements and you were injured as a result of this crime, either physically or emotionally or psychologically, then you can apply for the U visa. And it'll take 6 or 7 years, but if it's approved, you can apply for the green card 3 years after that.
Okay, thank you very much, Attorney Francis. And this is the next question, but let's go ahead and remind people that they can call the phone number 216-279-3984, 216-279-3984. Call the office and talk to one of the attorneys in the law firm of Margaret W. Wong. There are over 15 attorneys working in the law firm, working for you and helping you with your immigration case. So please give us a call. The phone number 216-279-3984. 7 cities: Atlanta, Chicago, Columbus, Cleveland, Nashville, New York, and Raleigh, North Carolina. And the phone number is just 1-216-279-3984. I lost my green card, passport on my last trip overseas. What is the fastest process to get it back? I also lost my license. I was given a visa to enter.
Okay, so is this person physically in the United States now, or are they stuck overseas?
I think he's in the United States because he
Okay.
says that he was given a visa to
Okay.
come back to the US.
So it's good news that you were in the made it back to the United States. So the fastest way to get your paperwork back is number one, you file an I-90. You can do that online. And the I-90 is to replace the lost green card. Now we've been getting pretty lucky getting these new green cards within a month sometimes, because before it was taking up to 2 years. And once you file the I-90, you have a receipt notice that you'll receive to confirm that your application was received by immigration. If you need to travel after that, you can use that receipt notice to apply for an I-551 stamp. That's a stamp in your passport that proves you're a permanent resident. You can use that to work and to travel, okay? And that stamp will allow you to renew your driver's license.
Okay, thank you very much, Attorney Francis. And so what I understand is that this person was given that visa for 1 month until this person can resolve the problem. So is 1 month enough time to get this solved?
Well, I mean, that visa or that paper probably was only used to allow him to get into the United States. So once you're here, there's no problem. You are a permanent resident of the United States. And so you just have to get proof of it. And so first you file the I-90 to replace the green card. And then you make what's called an info pass appointment with your local immigration office, showing that I-90 receipt so you can get the I-551 stamp in your passport. That is proof you are a permanent resident until the actual green card arrives in the mail.
Okay, thank you very much. Okay, we have another question coming in, and this person says, hi, good morning. I am gay. I am from Pakistan. Can I file asylum? I'd be killed if I go back to my country.
Okay, so if you fear for your life or you fear you'll be harmed or threatened if you go back to your country, you can apply for asylum. Okay, if you've never had an immigration problem before, never been put into deportation, you would file your asylum application, that's the form I-589, directly with the US CIS. Eventually, you'll be scheduled for a fingerprint appointment and then an interview at the local USCIS office. And in the meantime, if you've been waiting for longer than 5 months, you can apply for a work permit while you wait for that case to be completed. Now, one rule to remember is there's a 1-year rule. That means usually you have to apply for asylum within 1 year of coming to the United States. If it's been longer than 1 year, then you have to meet one of the exceptions to that 1-year rule. Otherwise, the Immigration Service might say you waited too long to apply. So I would recommend you speak to an immigration lawyer to give a few more details about when you came to the United States and why you decided to apply for asylum now, especially if it's more than 1 year since you entered.
Okay, thank you very much, Attorney Francis. And yeah, we'll have several questions coming in right now. And let me read one of them directly from the inbox because we don't have enough time to go back and forth with this information. So this next question says as follows. The name is Lori, and Lori says that she crossed the border in Detroit, and she came from Canada. She's actually from Nigeria, and she would like to know what her options are in the United States. She wants to get a work permit and probably get an immigration relief. So what are my options?
Well, my first question would be whether you entered legally or illegally across the border. Okay. If you entered legally, you have more options because if you came as a visitor, for example, on a visitor visa, then you could change your status from visitor to another type of immigration.
Excuse me, Attorney Francis.
Sure.
She says that she was paroled in through the border in Canada.
Okay.
And she wanted to apply for a refugee status.
Okay. So if you were paroled into the United States, you can apply for a work permit based on that parole. So usually parole is valid for 1 year. Okay. And so you can apply for a work permit for that 1 year period. Now, if you want to extend that work permit, then either you have to get a new parole document or you have to submit another type of application to immigration to qualify for that work permit. Now, you wanted to apply for refugee status in the United States, that means applying for asylum. So we just mentioned that's on the form I-589, which you will explain why you fear returning to your country. Has anything bad happened to you in the past? Were you harmed or threatened? Or has something changed such that you'll feel you'll be harmed or threatened in the future if you return to your country? Okay. Like I said before, there's a 1 year rule. So if you were paroled into the United States, make sure you submit that asylum application before you reach the 1 year period after you enter the United States. Okay. After you apply for the asylum, after 5 months, if you still don't have a decision yet, then you can apply for a work permit while you wait for the asylum decision.
Thank you very much, Attorney Francis. And well, these questions is really interesting. Let's see if you can help us understand this question. Hi, attorney. I've lived in the United States since 1995. My father filed for me, but he passed away due to COVID in 2020. The I-130 was approved in 2021 after his death. We didn't do nothing because we don't know what to do. The case is over, the case is lost, or there is something we can do since our father was an U.S. citizen.
Okay, so usually if the petitioner, that's the U.S. citizen sponsoring you, passes away, then the case is canceled. The petition is automatically revoked because there's no more sponsor. But the Obama administration passed a law for what's called surviving relatives. If you are physically in the United States on the date that your father passed away, and you continue to reside in the States from that date until now, then you can request that the Immigration Service reinstate. That means recertify, reapprove that petition, even though your father is no longer alive. Okay, so you are a surviving relative. So that petition is still good because you were physically in the United States on the day he passed away. The next question would be whether you qualify to use that petition to apply for the green card in the United States, or if you would have to go through the US Embassy in your home country. Now that depends on a lot of factors. Number one is whether you were under 21 or over 21, when did your father file that petition? Was it before 2001 or after 2001? How did you enter the United States in 1995? Did you enter legally or did you enter illegally? Okay. And do you have any legal status now, or have you been unlawfully in the United States this whole time? So I'd recommend that you talk to us to give us some more details so we can figure out, can you use this petition to apply for the green card in the United States? But don't worry, that petition should still be good.
Okay, thank you very much, Attorney Francis. Don't forget, the phone number is 216-279-3984, 216-279-3984. Attorneys in the law firm of Margaret W. Wong and Associates. They are able to help you in several immigration cases like asylum, cancellation of removal, waivers, U visas, VAWA, work-based visa like labor certification, EB2, EB3, or investment visas or special ability visas. All of those qualifications or classifications are worked in the law firm of Margaret W. Wong and Associates, and we have 15 attorneys that are experts in different areas of the immigration law. Just like Attorney Francis, he's one of the experts and one of the doctrinaries in the law firm that sets the path of how the law firm is going to work certain cases. So you want to talk to a good attorney that can take care of your immigration case. And the phone number is 216-279-3984, 216-279-3984, with 7 offices across the country: Atlanta, Chicago, Columbus, Cleveland, Nashville, New York, and Raleigh, North Carolina. And it's just one phone number, 216-279-3984. Okay. Next question is, can I file labor certification during a visitor visa?
So the answer is the PERM application could be filed anytime. PERM is the first step of the employer-sponsored green card process. If an employer is willing to sponsor a worker for the green card. And that PERM can be filed regardless of whether that worker is in the United States or overseas. The issue is going to be the green card process will take minimum 2 to 2.5 years. And when you're here on a visitor visa, number one, you're supposed to have temporary intention. I'm here to visit, not apply for the green card. And number two, you're only allowed to visit for up to 6 months. So you definitely can't stay here for that full 2.5 years as a visitor. So even though you do find an employer who's willing to sponsor you and you're here as a visitor, you'll need a plan on how to stay here for longer than 6 months, or you'll end up returning back to your home country and waiting for that 2.5 years for the green card to be approved.
Okay, thank you very much, Attorney Francis. Our time is up for today, so thank you very much for having us in this show. Attorney Francis, this is an election year, and generally in election years, what happens with immigration is it's part of the political campaign. Things seem to improve or to get worse during election years.
Well, I mean, during the election year, it seems like the candidates want to focus on issues that are important to voters. And right now, in the news, all the attention is focused on the southern border and what people are calling a border crisis. Okay. And so it seems like all the candidates are trying to focus on, well, how do we help solve this crisis? And unfortunately, a lot of the proposals are about border security, how to make it more difficult for people to come to the United States, make it more difficult to apply for asylum, more difficult to get these human rights that are supposed to be part of our history, and to protect people who are trying to escape threats or harm or persecution. So there's a lot of new policies being talked about and policies that are trying to go through Congress, but I don't think anything is actually going to happen or be approved just because of all this political turmoil. But there's a lot of rhetoric, a lot of talking about how to be tough on the border.
Okay. Well, let's see what's going to happen in the rest of this year and next year. Hopefully, things are going to get better in immigration. There are some things that the government has to fix, but also there are some laws that need to help the immigrants that have been here for several years, working hard and trying to help this country grow. So thank you very much, Attorney Francis, and see you soon.
All right, you're welcome.
Thank you. Have a good lunch.
Thank
And
you.
for everybody, thank you so much for having us today. Don't forget the phone number is 216-279-3984, 216-279-3984, attorneys in the law firm of Margaret W. Wong and Associates.